Well, let me officially start the webinar then, please. I'd like to welcome everybody to the Family Voice Religious Freedom webinar. The issue is when and what are we likely to see? Before I start, I'll hand over to David DeLima, who will open up in prayer by way of setting the tone for this particular webinar. Thank you, David.
Well, thank you, Greg, and good evening to everyone. Let's commit our evening's meeting now to God. Father, we thank you for the tremendous freedoms that we enjoy in Australia and in other nations of Western Foundation. We thank you that the gospel of Christ has infiltrated our culture and enriched our culture so wonderfully. We thank you that most Australians still are Christian, at least in the census, and we thank you for that wonderful foundation. We thank you also for the many Christian institutions, the hospitals, the schools, and hospices, and all sorts of places where your people, through their Christian commitment, are enriching society and helping those who are in need. And we do pray that the freedom of faith that has brought that prosperity and brought that opportunity will be guarded. And we ask that as a result of our session tonight, that all of us will be enriched and better equipped to seek to bring about the reforms needed in order to prosper freedom of faith in this nation. We ask this in Jesus' name. Amen.
Amen. Thank you very much, David, and thank you once again for the panel. For those that have just registered, I repeat that if there's a technical issue, please stay on board. I will restart the webinar should it go to a blank out. All right, well, welcome everybody. The format will be for those that are registered. Each speaker will get about 10 minutes to outline the issues that we are facing with the Religious Freedom Bill. And then once we've had the speakers, the panel present their position, we will go into a Q&A session. David DeLima will filter those questions, and you can do those questions through a Q&A on your panel or a chat button. So please feel free to do that. All right, by way of introduction, if I may, everything has a publicity angle. So I'm Greg Bondar, the National Webinar host, and David DeLima is my co-host. And of course, David is the South Australian, State Director. Our panel tonight is Rowan McHugh, and of course, Rowan is well known for his Executive Director of Freedom for Faith. And Peter Kurti, of course, Director of Culture, Prosperity and Civil Society Program. He's an adjunct associate professor in the School of Law at the University of Notre Dame. Senator, the Honourable Concetta Fierravanti-Wells, of course, is Senator for New South Wales, and we're delighted to have you as well, Senator. And not least or last, but John Steenhoff, who's Principal Lawyer, Human Rights Law Alliance. Now, each of these speakers are highly regarded in their own field, and on behalf of Family Voice, I do welcome you for joining us. If I could just mention, our next webinar will be on the 11th of October, and it will be an interview style, and I'll be talking to a chap called Tony McClellan, who was the former chairman of the Australian Christian Lobby. And Tony has written a book, a wonderful book, and it's an outline of his life as a Christian and as a businessman, and it will be a very much highly personal, highly interactive type of webinar. And joining Tony McClellan will be Nick Carter, who is, of course, Executive Director of the Menzies Research Centre, and Nick is also a co-author of that book. So that's by way of advertisement. Okay, if I can now take you very quickly in the next minute or so, just to let you know where we're at. The Attorney General's Department received submissions for the Religious Freedom Bill second exposure draft. There are over 7,000 submissions. Now that's critical, because we're going to have to argue how does a government come to grips with 7,000 submissions. And not only that, but they published on their website 290 submissions for people to look at. Now, have a look at this. This is what I'm seeing in the media currently. Coronavirus policy breaks applied on religious freedom and anti-corruption. This was back in May 2020 in the Australian. Then we have, at the same time, keep flower clause out of religion bill, law firms, Winterelson and Macquarie and Maurice Blackburn say. Very interesting. How about this? Just recently in June, a couple of months ago, right-wing backlash, church group to make religious freedom an election issue. And somebody here will be able to comment on that very shortly, I suspect. Then we have politicians that have spoken out. Here's Reclaim Your Religious Liberty, says George Christensen, and he's saying that, you know, we need the right to the Prime Minister and the Attorney General. But more importantly, earlier this year in February, we held a webinar with former Prime Minister John Howard. And of course, John Howard is a wonderful person from the point of view that he believes in religious freedom. And one of the things that he said was, John Howard calls for religious schools to have anti-discrimination exemption. And finally, just as of the other day, what do we have? We have the Australian reporting that the Attorney General, Michaelia Cash, what I would like is a bill that has support of the majority of Parliament. Well, good luck with that. But more importantly, she's saying that Michaelia Cash rules out broad, constitutionally barred religious freedom laws. Well, that really sets the scene, I think. So what we have to do is take that into account. I'll stop sharing my screen now. And let's try and make some sort of common sense out of all that information. What I'd like to do is, as I said, introduce the speakers, the panelists, and I'd like to introduce Rowan McHugh, Executive Director, Freedom for Faith. Okay, over to you, please, Rowan.
Well, thank you, Greg. And it's a pleasure to speak to everyone present here tonight. We at Freedom for Faith have been involved in consultations with the government since the bill was put back on the agenda earlier in the year. And we've been pleased to provide drafting advice on several clauses to ensure that the religious community is faithfully represented. It's important to say from the outset that this bill will be a helpful step in the right direction for religious freedom. Beyond the specifics of the contents, a federal bill of this kind will communicate religious freedom as a human right, not merely something that is subject to the creeping whimsy or demagoguery of state and territory politics. I think it's beneficial, however, if I lay out some of the limitations of the bill, providing some context for why many of the religious freedom challenges we face, particularly for religious institutions, aren't entirely captured by the bill in its current form. The last few years have seen a rapid erosion of religious freedom in Australia, and I'd like to give a few examples of where it has been either forgotten about or in some cases simply ignored. We've just seen a bill pass in Queensland giving hospitals and aged care institutions no choice but to facilitate euthanasia between external doctors and patients. Only 4 short years ago, Victoria passed similar assisted dying legislation without these kinds of restrictions on religious freedom. And a few months ago, the Western Australian government was in breach of its own anti-discrimination laws when it refused a Christian group the right to hire a state-owned venue. And although the minister reversed that decision, it appears that the public servants or staffers responsible weren't even aware that this could be a human rights issue. And the state of Victoria, which is in the wake of its deeply concerning legislation on conversion therapy, is now proposing to remove the rights of religious institutions, including schools, from staffing in accordance with their own ethos. If such freedoms are curtailed, there's little left that would distinguish religious schools from any other school, undermining the free choice of parents who wish to send their children to non-state schools. And it should be said that many of these parents are not religious and each pay additional school fees on top of their taxes. What's particularly troubling here is that the state and the courts are inappropriately inserting themselves into matters of doctrine and theology within religious communities. This is obviously not an absolute right of religion, but in the context of schools, strikes at the very heart of why they were established in the first place. The Victorian Attorney General seems to have forgotten that there is no value-neutral approach to education, and that the formation of the next generation of faith communities is not just in the imparting of knowledge and facts, but each staff member operating as a living example to the truth and goodness of their beliefs. Okay, so I'd like to just link this example back to the Religious Discrimination Bill. And although the proposed bill does enable a preferencing for staff in accordance with beliefs, all staffing choices will still be subject to the requirements of other federal discrimination acts, such as the Sex Discrimination Act, which forbids the refusal of employment or the termination of employment on the grounds of sexual orientation or gender identity. Now, religious schools are currently granted an exemption to these requirements of the Sex Discrimination Act, but it's important to realise that institutional protections of this kind fall outside of the scope of the proposed Religious Discrimination Bill. So if Victoria successfully passed their newly proposed bill to remove these staffing rights for schools, the Federal Religious Discrimination Bill would have no power to override those laws. But it is possible that the exemptions within the Sex Discrimination Act would override them. Our own board member, Professor Neil Foster, has written a paper recently that examines whether the proposed Victorian laws may indeed clash with these exemptions. It's possible that the Victorian laws would be deemed inoperable by the High Court if there was a constitutional challenge, on the basis that where Commonwealth law authorises something, a state law cannot take that away. And I'd encourage you all to read the piece on the Freedom for Faith website, but it goes without saying that even if such laws were overturned by the High Court, the millions of dollars in legal costs to reach such a decision is a high price to pay for religious freedom rights. The government had previously indicated that a review of these exemptions within this Act would be conducted by the Law Reform Commission a year after the passage of the bill. But if the exemptions within the Act that schools rely upon were removed down the track, it's at the very least unclear what power the Religious Discrimination Bill in its current form would have to protect religious institutions across the country, even where states haven't passed something like the proposed Victorian laws. So we'll just have to wait and see what the Law Reform Commission recommends. But if the trajectory of European courts are a guide, the removal of exemptions would be seen as a prioritisation of the interests of the LGBT community. And this is largely because although many religious groups hold to an orthodox sexual ethic, making a distinction between sexual orientation and sexual activity, courts and legislators are increasingly unlikely to do so. Indeed, the conversion therapy bill that has passed in Victoria defines sexual orientation as intimate or sexual relations with another person. So having a religious freedom framework that operates through an exemption model of this kind has been unfit for purpose for many years. And Freedom for Faith, along with many other religious institutions, have been adamant about the need for clearer rights protecting against discrimination, rather than exemptions which communicate the idea that the religious are being given a kind of unique authority to discriminate. The only provisions within the bill which may help are protections against what is called indirect discrimination. An example of indirect discrimination would be, say, if a Muslim woman who chose to wear a hijab and let's say she worked at a fashion store, if the owners wanted to stop her from wearing it, they could make it official that headscarves of any kind are prohibited by staff. And although this technically doesn't target the Muslim woman specifically, the effect of the rule is to indirectly ensure she can't wear one. Now, in the context of schools, it may be possible for a school to say that they are the victims of indirect discrimination, where, as I said earlier, the courts or legislators are failing to make a distinction between sexual orientation and sexual conduct, despite such a distinction being clear within their own theological tradition. But this is not likely to prevail in our cultural moment. And to wrap up, here's just a quick applied case. In Sydney, the very first Sikh school built in the Southern Hemisphere is soon to be opened. And I'm not suggesting to know the granular detail of Sikh theology, but if the state and courts continue in their erosion of religious freedoms, it will be hard for governments to maintain that Australia is a successful multicultural pluralist country if such a school's reason for being is thwarted before they can open. So crucially, faith groups should be given federal certainty about religious freedom rather than being subjected to what is gradual subversion by state governments. For example, the Commonwealth government could look more closely at sensible amendments to the Fair Work Act to insert religious freedom guarantees that are binding on the whole nation. So as far as religious institutions are concerned, the bill shouldn't be understood as a panacea for religious freedom rights, but it can be seen as an important part of our advocacy efforts in federal and state legislation.
Thank you, Rowan. Very good summation of where freedom for faith is at the moment. Could I now introduce, please, the Senator, the Honourable, pardon me, Fierravanti-Wells. She's Senator for New South Wales. Senator, if I may, pass over to you, please.
Well, can I thank you, Greg, for organising this webinar on an issue that is of importance to all of us. Can I also acknowledge and thank my fellow panellists, Peter Kurti, John Steenhoff and Rowan McHugh, all of whom are doing fabulous work in this space. Now, the Morrison government has stated that it believes that all Australians, regardless of their religious beliefs, should be able to fully participate in our society within the framework of Australian law. Now, the government has indicated it sees an opportunity to further enhance and better protect freedom of religion under Australian laws. And on this basis, the government prepared a package of draft legislation to implement recommendations from the May 2018 report of the expert panel to the Religious Freedom Review, including a religious discrimination bill. Now, the government asserts that it has conducted extensive consultations in 2019 and 2020 on the proposed legislation, including roundtable discussions and meetings with interested stakeholders. And I understand that approximately 13,000 submissions were received. Now, the government has also asserted that the right to freedom of religion is one right among many others and must coexist with the broad suite of human rights, including the right to equality and non-discrimination. Furthermore, the government has asserted that the Religious Discrimination Bill will ensure that religious belief and activity is protected in the same manner as other existing attributes covered by anti-discrimination law, including race, age, disability, and sex. And I understand that the Attorney General is working to progress the Religious Discrimination Bill and associated legislative package so that it can be introduced to Parliament before the end of the year. Now, Australians of family and faith want to be able to live their lives in accordance with their faith and their convictions. Now, before COVID-19, we saw the growing number of cases in Australia of people facing harassment, intimidation, and persecution, some even losing their livelihoods because of their religious beliefs and actions. Indeed, in a series of speeches in the Senate, I have highlighted a number of these cases and the need for positive religious freedom laws. However, serious transgressions against religious freedom have worsened as a consequence of state health orders imposed under cover of COVID. When freedom of speech, thought, conscience, and belief is framed only as an exemption to other rights, they are read down against positive rights, rendering them subordinate to those other rights. So a regime of positive rights in the form of religious freedom legislation would give greater effect to the right to manifest one's freedom of thought, conscience, and belief, as outlined in Article 18 of the International Covenant on Civil and Political Rights. And for this reason, in June 2019, I launched a petition in the Senate calling for the enactment of a Religious Freedom Act to protect the rights to freedom of speech, thought, conscience, and religion. Now, following this, I was able to table tens of thousands of original hard copy signatures, and I'm very grateful to the people who took the time to sign the petition. Now, we know that in August 2019, the government released the first draft of the religious discrimination bills. Following almost 6,000 submissions and strong pressure from religious leaders, experts and stakeholders from across the faith spectrum, on 10 December 2019, the second exposure drafts of the bills were released. Now, whilst the second draft did address some changes, there are still major issues of concern, and I just want to highlight some of these. Concerns, I think, remain about adequate definitions of religious bodies being involved in commercial activities and hence affording them proper protection when they do so? Are the legal protections from discrimination to religious corporate bodies and unincorporated associations sufficient? Will legal and financial protections be properly afforded to charitable organisations? How do we properly ensure full legal protections to religious bodies to preference the employment of staff that support the religious ethos of the organisation, as well as to religious bodies to preference people of faith in the use of their facilities? Ensuring maximum protection to health practitioners who seek to exercise conscientious objections and protections for employees to make statements of faith at their workplace or private time without fear of retribution from their employer. A further concern is that the current bills do not extend to state vilification laws, which is where the majority of the legal disputes have occurred. And this will continue to occur in the future because the current bills do not override state laws. So I go back to the last federal election when the Israel Folau case featured prominently. Now, at the kitchen table, Australians of family and faith ask themselves, if I say something about my religion, will I find myself in trouble? Now, the legitimate fear arose. If it can happen to Israel Folau, it can happen to me. And that fear remained that a person could face the legal hassle of being hauled up before a court or tribunal for simply quoting from the Bible. Now, the Folau issue heightened an already existing concern about incursions on religious freedom. For ordinary people of faith, the perception remains that quoting the Bible will get them into trouble. So can I applaud the continued solidarity of religious leaders? They may have different theological differences, but only with strong solidarity will they remain unified in their fight to achieve protection of freedom of speech and freedom of religion. Now, I go back to the joint letter from faith leaders to Scott Morrison and then Attorney General Christian Porter, dated 22 November 2019, and I quote, "In its current form, the bill will diminish the religious freedom of faith groups in Australia, and we take the view that it would be better to have no Religious Discrimination Act than a flawed one." Now, at the time of the last election, the Morrison government promised that people's religious freedom would be protected. However, what they are being afforded is some protection against discrimination. As I have repeatedly stated, ultimately, Australians of family and faith will look to assurances given by faith leaders to their congregations that the bill fully protects their religious freedom. Now, whatever the politicians may say, what matters here is what the faith leaders will preach and tell their congregations, which will dictate if those expectations have been met. Now, in short, unless those faith leaders assure members of their congregation that what happened to Israel Folau will not happen to their congregations or members of their congregation, then the threshold for adequate protection will not be met. And in conclusion, as I have publicly advocated, the current bill, certainly as has been presented to me by many people, there is a strong belief that it falls far short of adequately protecting religious freedom. And it reinforces my view, and I think the view of many others, that no bill is better than a flawed bill. Rather, I have maintained that a nationally consistent approach should be adopted that would see a consolidation of Commonwealth and state discrimination law. This would afford a more effective and long-term solution that would ensure equality of rights and conformity of Australia's international obligations. I believe that this is the only way that freedom of speech, thought, conscience, and religion can coexist on an equal footing with other rights. Thank you.
Thank you, Senator. A wonderful summary of where we're at. We'll come back to you because there are a lot of questions, I think, that will ensue from that particular commentary. Could I now please introduce, if I may, Peter Kurti, who is in the School of Law, University of Notre Dame. Peter, over to you. Thank you.
Thank you, Greg, and thank you for your invitation to participate in this evening's webinar, along with Connie, Rowan, and John. The issue of religious discrimination remains an important topic, even though it has been somewhat overshadowed by the COVID pandemic. So it's good that we can devote time to it this evening, especially as we've heard the Attorney General appears to be getting a final draft of the bill ready to take forward to Cabinet and the Parliament. Now, Senator Fierravanti-Wells has already referred to the Morrison government's commitment to protecting religious freedom, which was first promised in the 2019 election campaign, in the wake of the campaign for same-sex marriage and the report of the Ruddock Review. And I think she's very precisely put her finger on the heart of the problem, because since the Ruddock Review made its findings known, there has been disagreement about the way in which religious freedoms ought to be protected and the way in which they're understood. Now, I've no doubt that the revised proposals will prove just as controversial as those first put forward by Christian Porter. And critics of the bill will almost certainly argue that any kind of religious freedom protection amounts to support for hate speech and prejudice. And yet, far from creating a license to pursue the socially unacceptable, enactment of some form of legal protection for the fundamental right to religious liberty will only strengthen the capacity of citizens of an already successful and diverse multicultural society to live together. Of course, as we've heard, a law offering protection from discrimination is not the same as a law upholding a positive right to religious freedom. Anti-discrimination law simply says that religion is a protected attribute and that any rule which has an adverse impact on faith must be justified. Anti-discrimination law, therefore, does not uphold a positive right to religious liberty. It's more of a shield than a sword. Even so, I think the fact that the government is prepared to take an anti-discrimination approach indicates the importance of the issue, which was, after all, an election promise. But what is it that's brought this country to the point where legislation is needed to protect the practical exercise of religious faith? One factor surely is the advancing reach of identity politics, which accentuates rather than ameliorates differences between people. Accentuating difference, in turn, makes it harder for citizens of a secular, multicultural society to dissent from the new orthodoxies about gender, human sexuality, the family, euthanasia. Dissent is weaponized and deployed as a form of alleged harm in order to shut down debate. Now, we know that critics of religion regularly pounce on the 2016 census figure of 30% of people claiming no religious affiliation. But what they consistently fail to see, or refuse to see, is that religion remains an important part of Australian society, and that over 60% of Australians retain a religious affiliation. And a law that protects the religious practice would not have been necessary had it not been for the intolerance shown by those determined to silence and shame religious believers who dared voice their beliefs in public. Indeed, any expression of sympathy for religious points of view on social issues can lead to condemnation and the call for boycotts. Legislation, or rather the legalization of euthanasia, as Rohan has pointed out, poses the next set of problems for defenders of religious liberty. A faith-based health or aged care facility is likely to find that its freedom to refuse administration of euthanasia on its premises removed by laws enshrining the so-called right to die. It's happened in Queensland, as Rowan has already noted. We're waiting now to see what kind of bill is going to be presented in New South Wales. But the categories will expand, and it will become harder for people with a religious faith who are operating faith-based institutions to, or I fear it will become harder for them to resist the secular pressure to conform. Now, Australia long ago signaled a commitment to protecting religious liberty when it ratified the Universal Declaration, which Connie has referred to, and the International Covenant, which is also referred to. These are two of the principal treaties setting, or international instruments rather, setting out protections. Ratification of such instruments does not automatically make the provisions part of Australian law, and it does not create legally enforceable rights. but I think it does entail a legal and moral obligation on the part of Australian parliaments to act consistently with the instruments and to uphold their provisions. The unrelenting onslaught of progressive secularism is making it ever harder for religious Australians to practice their faith openly and in public. And now we've come to a point where a religious discrimination bill is not only to be welcomed, it has become essential. The tyrants of tolerance, as I dub them, have only themselves to blame for having so taunted their religious neighbours that the Morrison government, which came to office pledged to act, has now demonstrated a renewed determination to safeguard the liberties of all Australians. Thank you.
Thank you very much, Peter. I'm going to come back to you because I want to get a legal angle as well. And of course, talking legal, John Steenhoff, Principal Lawyer, Human Rights Law Alliance. John, over to you and give us your perspective on where we're at the moment. Thank you, John.
Thanks, Greg. Thanks for inviting me to speak this evening, and thank you to the other panel members for some excellent presentations. There's nothing as exciting as getting a lawyer to finish off a panel presentation. Almost exactly 18 months ago, I gave a talk in Adelaide titled "The Morrison Government's Religious Discrimination Bill." Since that talk, there has been glacial progress on this religious discrimination bill. Yet, in the same period, we've seen a whole raft of legislation that have been passed that are hostile to Christianity and the Christian worldview. We've seen conversion therapy laws in Queensland, ACT and Victoria. We've seen abortion and euthanasia laws in Queensland and New South Wales. And we're seeing proposed extended vilification and hate speech laws all over, including Victoria and Western Australia. So while the legal landscape on progressive issues has seen massive tectonic shifts, on religious freedom, nothing's changed. Protections for religious people are pretty much stalled. And this fact alone should give you some indication of the current zeitgeist and an indication of what's next for Christians. The short answer to that question, what's next, is that Christians are increasingly going to find themselves more at odds with the culture and particularly with laws, and will be facing increasing cultural hostility and legal sanction. And the sphere in which Australians are allowed to be religious is ever narrowing. A survey by the ABC in late 2019, the Australia Talks National Survey, confirms this. So 71% of Australians say that religious discrimination happens occasionally or often. So Australians recognise that religion gets a raw deal. Yet most of those same people, 60% of them, would prefer that people of religion keep their religious views to themselves. Now, contrast that with how religious freedom is recognised, certainly in international law. There's been reference already to Article 18 of the International Covenant on Civil and Political Rights. And I just want to spend some time on that at the moment to give some context for the Religious Discrimination Bill. Article 1, or paragraph 1 of Article 18 says, everyone shall have the right to freedom of thought, conscience, and religion. This right includes the freedom to have or to adopt a religion or belief of your choice, and freedom, either individually or in community with others, in public or in private, to manifest their religion or belief in worship, observance, practice, and teaching. It's a very, very broad right. So the cultural concept of religion being an intensely personal thing that we should keep in the synagogue, in the mosque, or in the church is completely at odds with the internationally recognized freedom of belief. And what kinds of limitations are acceptable internationally to freedom of belief? Well, freedom to manifest your religion is subject only to such limitations as are prescribed by law and necessary to protect public safety, order, health, morals, or the fundamental rights and freedoms of others. So you see that at international law, the right to religious freedom is a broad and capacious right. It is a right that can be exercised individually or in community with others, in public and in private. Now, in Australia, there is no formal real protection of religious freedom. The ICCPR is a treaty only that we are parties to. Constitutional protection is very limited. And really, the reason that Christians have freedom in Australia is because it's part of a heritage that has been baked into our culture and law without formal expression. But as culture and laws change and the zeitgeist and our cultural currency changes, what happens to those freedoms? I think other speakers, and particularly Peter and Rowan, have talked about what is happening and what we're seeing in culture. And it's in that cultural context that the Morrison government introduced a religious discrimination bill, as promised in the 2019 federal election. Now, what is the bill supposed to achieve? Well, let's talk about what the bill is not meant to achieve. The government's bill is not a blanket protection of religious freedom for Australians. It does not address the extensive scope of the rights that come from religious freedom that are encapsulated in the ICCPR. It is a narrowly conceived and fairly focused piece of legislation. So it is not a cure-all or a panacea for religious Australians. What is the bill meant to achieve? As Peter and Concetta have said, this is a bill that protects religious Australians from discrimination only. And that's interesting. You see, if your only tool is a hammer, then everything looks like a nail. And in Australia, the rights discourse has been disproportionately focused for the last decades, many decades, on discrimination law, on the protection of particular people from unfair treatment, so that the natural instinct when looking at threats to religious freedom has been to protect them by extending discrimination protections to Christians. So the bill's stated aim is to outlaw discrimination against religion in public life and to enhance the legal protections of the right of freedom of religion in Australia. And really what it does is plug the gap and bring religious freedom into line to have the same and similar protection against discrimination as other protected attributes like sex, disability, age, race, sexuality, and gender identity. So what is it that we're looking for in this religious discrimination bill? We've had 2 exposure drafts from former Attorney General Christian Porter, and we now have Attorney General Michaelia Cash, who expects to produce a further 3rd draft of the religious discrimination bill very shortly. What do we want to see? Well, I think what needs to be in the bill for it to be a worthwhile bill is recognition of the unique characteristics of religious freedom rights compared to other attributes. The ICCPR makes clear the right can be exercised in public and private. It's not only for individuals, it's also for people acting collectively. There's a great article in the Weekend Australian by Mark Fowler, which speaks to this if you have a chance to read it. I think a religious discrimination bill to be effective also needs to reflect the international standard that's very high for limiting religious freedom. Religious rights are fundamental rights, and they should only be limited where absolutely necessary. If you have a low bar test for limiting religious freedom, it's going to hollow out meaningful protections. And we've seen this in many foreign jurisdictions where there has been disproportionate unfair treatment of Christians, where they've been kicked out of universities, lost their jobs, excluded from adopting children or fostering children on the basis of benign expressions of Orthodox Christian belief. If your standard for limiting religious freedom is low, a religious discrimination bill will have limited utility. Another thing we want to see in a religious discrimination bill is a law that avoids making the courts into theologians. Courts are very bad at theology. At the present time, in the state jurisdictions which protect religion, religious litigants need to go to great lengths to prove that their beliefs and their practice are in accordance with the doctrines, tenets, and beliefs of a particular religious group or denomination. In a case we ran in Western Australia, we had to get 3 theological experts to give evidence just to ensure that we could bring the court on the journey to understand their fundamental beliefs. This is expensive, costly, and time-consuming, and isn't what we want to see in a federal bill. We also want to see the protection of reasonable expression of belief. As Senator Fierravanti-Wells said, everyone who is of religious persuasion has a fear that they will be the next Folau. And indeed, in the first 2 drafts of the Religious Discrimination Bill, we had protections for employees in their own time. An employer doesn't own their employees outside of the workplace. The workplace itself is already a hostile place for Christians. We have clients all over Australia who have faced hostility both in and outside of the workplace for their religious views. This is not just a Folau clause. This is a clause for Ian Shepherd, the teacher in Alice Springs, who was harassed in his school teaching job for expressions of faith on Facebook. We have Madeline, the employee in Canberra, who was fired for saying it's okay to vote no in the same-sex marriage campaign. We have Amanda, a university student who was almost kicked out of her social work course for objecting to receiving an Ida Hobbit Day promotion from her lecturer. And the last thing we want to see is protection of religious organisations. Churches, schools need to be able to maintain their distinctive religious character with staffing and membership, and Rowan has addressed this well. If these core issues can be covered off in a religious discrimination bill, and if they get it right, this is going to give some limited protections, but real protections for religious faith in Australia. What are the dangers to look out for? And this is where I will close my talk. The first danger is that we get a lukewarm rehash of existing discrimination laws that fail to recognise the importance of religious freedom. Merely cutting and pasting the protections given to disability or to sex don't work for religion, which is of a different character. The second danger is a lack of conviction within government. These laws are formed and hashed out in the Canberra bubble, and there's a general lack of appreciation among the people I'm seeing increasingly referred to as the laptop class of the importance of religion, which means our politicians have very limited exposure to the real everyday Australians who are facing hostility for their faith. The third danger is a capitulation to the aggressive campaigns being run against the bill from everyone from Michael Kirby, the former High Court judge, and right down to Equality Australia and the pre-COVID pandemic campaign with Ian Thorpe. They were very polished, but they were ultimately scaremongering campaigns which radically caricatured the protections of the bill. And the last danger of this bill is that of Christians. Christians who expect cultural change through a religious discrimination bill are a danger. This bill will not make Australia a more harmonious place. It will not relieve magically the pressure on Christians in culture or hostility in the workplace. The cases that we run at the Human Rights Law Alliance are not going to change the cultural zeitgeist, even if we win most of them. It is the gospel, the Christian gospel, that does that. Christians who live as people of integrity and moral and ethical standing, Christians who speak publicly for their beliefs, pastors who are willing not only to speak truth in the pulpit, but also to act as public theologians, and churches that give a real alternative community to the increasingly individualistic values of our society are going to be the things that change Australia. So the danger for Christians is to expect this religious discrimination bill to do the heavy lifting. Christians need to do that for themselves. So to end off, I would say we need to pray for an effective religious discrimination bill, but continue to proclaim the gospel and live as citizens of heaven, serving King and Creator. Thank you.
Oh, thank you very much, John. Outstanding. You did refer to a couple of issues there that I'll come back to, as did Peter Kurti. But what I'd like to do first of all is put it out to the Senator, but of course you can all answer the question, and David will then come in with the questions from the floor. And I should explain, this webinar will go till 8:30, so there's plenty of time for questions. Okay, the Prime Minister and the Attorney General have both mentioned that faith communities need to lower their expectations. And John, I think you referred to that as well. Is there going to be an electoral backlash, so to speak, if our expectations are not met? Senator, first.
Sorry, Greg, could you just repeat that? You went in and out, in and out. I didn't hear you very, very.
My apology. 1, 2, 3. Can you hear me okay?
Sorry, in and out. Apologies.
All right. Okay. I'm happy you're getting reception okay. Can you hear me okay, Senator?
Yeah, look, start again if you wouldn't mind asking
sure.
the question.
Yeah, a very quick question. The Prime Minister and the Attorney General have said that faith communities need to lower their expectations. Can they expect an electoral backlash if our expectations are not met, Senator?
Well, Greg, this was the point that I made when I spoke, and that is that the last federal election, we clearly went out and said, we protect your religious freedom. And I know I worked and spoke with a lot of communities, particularly in southwestern Sydney, in areas, you know, a lot of the areas where I operate in and have connections are very much those seats where there are a lot of migrant communities, and most especially those communities that strongly voted no in the same-sex marriage survey. So if we've gone out and said we're going to protect your religious freedom, and it comes back to the point that I said before, ultimately the arbiter of whether that religious freedom has been afforded is going to be the imam, it's going to be the bishop, it's going to be the priest, it's going to be the pastor, it's going to be the religious figure who's going to stand there. It needs to be assured that this bill adequately protects the members of his congregation. And I think that unless he can give those assurances, then all he will say is this bill does not meet the expectations and the promises that were made at the last federal election, and therefore your religious freedom have not been protected. I think that ultimately is, you know, the situation, particularly when you are dealing in areas such as southwestern Sydney, where you do have religious communities and communities who supported us, who changed their votes because they felt that we were in a better position to protect their religious freedom. And so therefore we will need to meet those electoral expectations.
Thank you, Connie. As you know, Bill Shorten lost the election because he ignored the Christian community in a lot of ways. So this could be a political issue for the Morrison government. Okay, David, are you ready to go with questions on the floor, please?
Yes, absolutely, Greg. So the first question on to Senator Concetta. Peter Kurti has mentioned the rise of identity politics as one factor in how our society has got itself into the situation where our fundamental freedoms are being eroded. Do you have anything to add to that? And what's happened to loving our neighbour? What's happened to community where we recognise a diversity of opinion?
I think what's happened, I follow very much Peter's writings, and I'm a fan of his work. I think the reality is that the advent of social media has, I think, degenerated the marketplace, if I can put it that way. The electronic marketplace is now dominates in a shrill, at times very nasty way, and often the silent majority and many of our people of family and faith are in the silent majority. They are not the sort of people that descend into what I call the electronic marketplace. And so therefore, I think that in many ways, they have been crowded out. And that's why ultimately I come back to the point that I made earlier. What is going to be important is those ordinary Australians of family and faith, unless they feel that their expectations have been met, then I think that I don't think that they are going to feel that political expectations have been met. And unfortunately, and I think I go back to what John said before, ultimately, we, those of us who have faith, we have to stay strong on this, because ultimately there may be in existence a piece of legislation, but ultimately what's going to make religion strong in this country, if those people who adhere to religious beliefs are prepared to stay strong and be prepared often against the backlash to maintain their values and beliefs.
Thank you. David,
thank
one
you,
more?
Yes, another question for Senator Connie. The society doesn't seem to be recognising the value of the Christian institutions such as schools and hospitals, which are so massive and so valuable. Why is that? And are those organisations adequately explaining the value of their work to the community?
Well, I think that we saw a lot of this when we fought to maintain the exemptions in the Sex Discrimination Act, when there was the onslaught, particularly against the schools. I think it's ultimately, my sense is that those who have the agenda of reducing the role that religious schools and religious hospitals play in society. And that troubles me, because ultimately, I think that this is one of the reasons why those who believe that education should be only a public education, and who continue to lobby against subsidising of religious and particularly low fee paying religious schools. I think that that's part of the agenda here. It's not just about the religious component of it. I think it's part of that sense that there is a greater ability to control the situation and control the education of young people if we take it out of a religious context. And that troubles me, because that will take away choice from parents. And it troubled me to see some of the evidence that was given, particularly during the same-sex debate. Sorry, not the same-sex debate, the sex discrimination hearing that we conducted in relation to the attempt to remove those exemptions from the Sex Discrimination Act for particularly schools.
Thank you, Connie. That brings a question I'd like to put to John and Peter, and of course Rowan as well. The Australian Human Commission, Racial Commission, said that religious groups should not be protected. A legal question: can a religious freedom bill protect a corporation as distinct from an individual? Can a corporation hold a view as an individual can? So is that going to pose a problem from a legal perspective, John or Peter?
Thanks, Greg. I'm happy to have a first stab at an answer and let Peter correct me. Conceptually, it is a law is capable of being passed that will give adequate protection to religious organisations. There's nothing equally wrong conceptually with the idea that organisations have fundamental beliefs, fundamental religious convictions. You can find these in their constitutions, you can find these in their governance documents, in their policy and practice. We have airlines that they put their stick in the sand, their marker down for marriage equality. We have organisations that take a stand on climate change and all these kinds of issues. There are ways of recognising that an organisation has beliefs, and there's ways of protecting the organisations in a law, in a federal law. There's two ways of achieving it. One is by putting in an associates clause, which allows a person who is a member of one of those organisations to take claims on behalf of that organisation. The other way is to just allow those organisations themselves to be able to take claims and to prove their beliefs on the basis of their documents and their practice. However, there is a huge amount of opposition to this. The Human Rights Commission says that human rights are for humans. However, a lot of religious endeavour is done collectively. The ICCPR itself says that religious freedom rights are exercised both individually and in community with others. So you really are going to miss out on giving protection to religious freedom effectively if you're only going to allow individuals.
Thank you. Peter, Kurti, quick comment.
Thanks, John. I agree with you completely. I would just add maybe a cultural note about that. With the passage of the Queensland euthanasia law recently, I wrote something, and somebody said to me, "Well, how can a building have beliefs?" Which I thought was, in a way, was to fatuously misunderstand what was going on here and what the issue was. Because I think that a faith-based organisation has an ethos that governs the way in which it conducts its business, the way in which it recruits its staff, the way in which it shapes the service that it provides. And I think if we simply say that human rights are for individuals alone, we really stop short of recognizing the important contribution that faith-based organizations such as schools, hospitals, aged care facilities make to our community, where there is a difference. And it has to be said, picking up a point that Connie made earlier, these services are very popular with the Australian people, and people use faith-based schools, they use faith-based hospitals, and they use faith-based aged care facilities. And I think that it's only common sense to recognize that those institutions ought to be entitled to govern themselves according to their ethos.
Thank you, Peter. David.
Yeah, question for John, please. Will the proposed Freedom Bill override state anti-discrimination and anti-vilification laws?
Thanks, David. The second exposure draft, which was released by Christian Porter, gave some protection against discrimination claims under state laws, and in particular, what's commonly referred to as the Archbishop Porteous case, where he was sued under a Tasmanian law, which makes it an offence to cause someone else offence or to offend them for his stance on Catholic teaching on same-sex marriage. It is not going to override, at least in the versions to date, it's not going to override vilification provisions. So it does provide very, very limited protection, because the place where most Christians are being harassed and where their beliefs are being challenged is through vilification statutes or the vilification provisions in the discrimination statutes in the states. It would be good and more effective if the religious discrimination bill also extended to vilification offences in the states to protect reasonable expressions of belief from accusations that they are themselves harmful or vilifying.
Thank you. And still to John, in the Commonwealth Constitution, section 116, there is a ban on imposing a religious test or prohibiting religious observance. What about extending that to the states? That's to John.
That's to me?
Yes, yeah. Please.
So the religious freedom protections in the Constitution are very, very limited, and they only apply to Commonwealth laws and not to state laws. If one was looking at extending them to the states, it's not something that can be done by the federal government itself. It has limited powers to override state.
No. But can the states take that up themselves, though? Would that be valuable? or not?
It hasn't proved to be a very effective provision in the Commonwealth Constitution for the protection of religious freedom to date. So I don't know that it's going to add much more if it's introduced at a statewide level.
Okay, thank you. Question for Rohan. Could you just highlight once again what are the problems with the exposure drafts of the bill, particularly the current exposure draft?
Yeah, so if I go back to my original comments, one of the issues that John just spoke about is that the bill itself would not override laws in state jurisdictions. So when it comes to the Victorian laws that may be coming that would say we're going to rescind exemptions in Sex Discrimination Act's local ones, if they were to do so, then the Religious Discrimination Bill would not have the power to override those state laws. And in our discussion with various government representatives, they have said that they're not interested in interfering with state jurisdictions in that way. So I think that's one of the biggest ones. I think it's more what I think is sort of avoided or ignored in the discussion is that the Sex Discrimination Act exemptions are what currently give many of the freedoms to religious institutions, and they're in many ways the linchpin, and they operate alongside the Religious Discrimination Bill that's currently proposed.
Rowan, just on that to follow up David's question, I alluded to earlier an article from the Sydney Morning Herald that a right-wing religious organisation is going to use religious freedom as an election issue. Now, I alluded to earlier about an electoral backlash. Rowan, I'm sorry to say, but I think that might be referring to your organisation if the article's correct.
Yeah.
What would be the issues that you would raise in such an election issue, Rowan?
Well, I think that article was in response to an initiative that we ran a few months ago called the Religious Freedom Weekend. Now, that was simply to draw attention to the backbenchers across the political spectrum about the importance of religious freedom, and then also to encourage people within all faith communities of Australia to contact their local federal representative and make a case for religious freedom. So unfortunately, that seemed to translate into the idea that it was a federal issue, election issue or something like that. But it really was just an initiative to bring light to the issue. And there was no will on our part to make it a so-called election issue. So
Guru, never let facts get in the way of a story. Okay.
That's right.
David, over to you.
Yes, still with Rohan, are there constitutional questions that are going to arise? Are there going to be High Court challenges to the legislation? And isn't religion a state issue?
Well, the latter question, religion's both. So religion is a protected attribute in anti-discrimination law in every state except South Australia and New South Wales. But that potentially will soon change. There have been consultations with Attorney General Mark Speakman in New South Wales to include religion as a protected attribute. Now, sorry, David, what was the first question?
Yeah, about the constitutionality of the proposed bill.
Yeah, so I'm not aware of specific constitutional concerns. All I would say is that the constitutional guarantees for religion are something that have been gradually whittled down to very little over the decades. And so if one was to turn to the Constitution for religious freedom protections, they wouldn't find much there. But in a general sense, if I refer to my previous comments, that constitutionally there may be future challenges if things like the Victorian bill were to be successful, because, and I'm gleaning this from Neil Foster's work recently, if a Commonwealth guarantee in law was compromised directly by a state law, such as exemptions to the Sex Discrimination Act being contradicted by potential laws in Victoria, then because they would be deemed to run concurrently and Commonwealth law supersedes it, then that might be a constitutional issue that the High Court rules on to say that religious freedom is protected and the Victorian law is rendered to not apply. So that could be a future constitutional challenge that we see.
Okay, watch this space. So question for Peter now. There's been some talk about a freedom of religion commissioner. Is that still on the table? What are the merits or otherwise of having a freedom of religion commissioner?
I understand. I haven't seen the latest exposure draft. I'm not sure that there has been an exposure draft yet. I understand that the position of Religious Freedom Commissioner has remained in the draft proposals. I think what it does is the creation of such a post would signal seriousness on the part of the federal government to the effective implementation of what is essentially new legislation. Clearly, there will be some detailed provisions. The implications will have to be worked out across the country. And I think the appointment of a commissioner suggests that the government really does take the implementation seriously and wants it to be done effectively. Whether or not that role will end up being created, I don't know. But I think it shows that the government is serious about at least the issue of religious discrimination.
Peter, thank you for that. I just want to get back to John for a moment, or all the panelists actually. Look, I'm a bit of a conspiracy theorist here. Let's say that the bill comes out, the next exposure draft comes out in October by the Attorney General. There will be no doubt, I suspect, some sort of consultation period. Now, is it logistically possible? Scott Morrison went to the election in May 2019. If he decides to hold it at the same time in next year, or even earlier, are we actually going to get a religious freedom bill through in time for the election? Or is it going to be shelved again like Christian Porter did? Comment from anyone, please.
Well, can I go first on that very briefly and say that I think that if that because Scott Morrison went to the country with that as a promise, as a serious commitment, and somebody who professed his own deep commitment to the Christian faith, I think if the government fails to deliver on this fundamental promise, it will be a weakness, and campaigning will draw attention to that. Whether or not that will be fatal to an effective campaign, I don't know. But I think enough people have enough invested in this, and of course, it's not just the Christian churches by any means, but enough people have enough invested in this to want to make the point that the government needs to deliver on its promises.
Thank you. Anyone else?
Can I just add to that? Assuming that it gets passage in the lower house, then it would come to the Senate. There is no doubt that it would be referred to a committee and would have to be examined by a committee of the Senate, as you know, for example, the exemptions to the sex discrimination were considered, which would raise all the issues again of consultation, submissions, etc. So given where we sit at the moment, it is, and I'm only looking at it from a purely logistical perspective, for that to properly happen, it is possible that committee may still be hearing and still be undertaking hearings, and the matter may not have been considered by the Senate, depending on when the election is. So, of course, that's another issue. What the logistics are in the Senate and where different people, and we know that there are deep divisions in the Senate by different parties in relation to this legislation.
Thank you. Anybody else, or over to David? Okay.
Thanks, Greg. So a question for Peter. Is anti-Semitism on the rise in Australia, and will this Freedom Bill be of benefit to minimise the occurrence of anti-Semitism?
Well, I don't think legislation will stop behaviour, and John made the point earlier that legislation is not going to bring about cultural reform. I think what legislation can make people think twice about doing things that might end up leading them to face proceedings. So we would just need to wait and see. There is a problem of anti-Semitism in Australia. I think there's a problem with left-wing anti-Semitism, and I think there is a problem with right-wing anti-Semitism, and they tend to manifest themselves in different ways. Right-wing anti-Semitism is often directed at the practices of individual Jews or the members of Jewish communities, whereas left-wing anti-Semitism tends to be veiled in what I call the moral righteousness of attacking Israel. But they both have the same effect in a way, and I think can both be very dispiriting and demoralizing for Jewish members of the community.
Well, thank you, Peter. A question now for John. Here in South Australia, recently the Parliament made a ban on Christians basically trying to minister close by or next to the abortion clinic. And the question was raised in the Parliament, is this going to ban silent prayer outside the abortion clinic? And the Attorney General said, oh, no, not at all. And then the questioner, who in fact is a minister in the Parliament, said, well, in that case, thank you for your assurance, but in that case, can we not write that into the legislation? And so the lower house of the Parliament declined to put that into the legislation. So does that mean that a Christian getting close by the abortion clinic, silently praying, could be in trouble with the police? The matter would go to the court. The court, looking at the second reading debate, could conclude that the Parliament declined not to legislate to allow for black letter law to permit silent prayer by Christians, and therefore you're guilty of an offence. Sorry for this long question, but would the proposed Freedom Bill, John, assist in that matter?
It's a good question, David. There was a case about abortion exclusion zones that was brought directly to the High Court, and Justice Edelman, in his decision, said that women passing by seeking abortion services could feel judged even by the silent disapproval of someone protesting in that exclusion zone with silent prayer. So that suggests that even silent prayer could result in a conviction under exclusion zone legislation. However, on the other side, there is the case in the ACT, which also has exclusion zones, of a number of Catholic monks who were through the exclusion zone with their rosaries in hand. They were praying under their breath. And the judge dismissed the case against them on the basis that there was no evidence that anything that they were doing was in opposition to abortion. So I think it's going to depend heavily on the facts of the case. But the hesitance to include any sort of specific protections in this kind of legislation to balance what the purpose of the legislation is against unfairly targeting people of Christian persuasion. They've clearly said, no, we're not going to put anything in there to clarify it, is a common thread across a lot of this increasingly hostile legislation that's being passed, such as conversion therapy laws, etc. There would have been easy ways to ensure that you weren't overextending the reach of these laws, and parliaments have declined to make those changes or to put in any balancing clauses for religion and for Christians in particular.
Mm. Wonderful.
And still with John, you mentioned earlier that surveys have shown that a lot of people think that religious people should keep their religious views to themselves. But I wonder if a different question would yield really an opposite answer, which is, if people were asked, should not someone have the freedom to explain their beliefs in conversation, either asked or just venturing an opinion, this is what I believe? If that question were asked, would there be a different result?
I think so, David. It all depends on how you ask the question. And there's a great Yes Prime Minister sketch on the most effective ways to do opinion polling to get the results you want. You can look it up on YouTube. It's fantastic.
Yes, indeed.
John, very quickly, while just we're on that, there's a view out there that says, be careful what you wish for. Religious freedom bill can be a two-edged sword. For example, I had representation from a particular mother that was very concerned about a satanic group that said they were a religious group. Now, are we going to give them freedom as well to undertake their particular practices. So they're issues that could arise with a religious freedom bill. John, Peter, or Senator.
Sure, Greg. This certainly is a pressing concern, is that it's going to have some unintended consequences. If the test for determining a religious belief or religious activity is appropriately formulated in the bill, I think you can avoid those kinds of results, and particularly where you look at a sincerity test, which measures whether the person sincerely believes what it is that they're asserting. And one of the things that will support that is if they are adhering to the doctrines, tenets, and the beliefs of a recognized system of religion. When one pierces through the thin veneer of the satanic movements throughout Australia, you'll just see most of the time a bunch of childish atheists whose unifying theme is a hatred of religion and not a real and sincere belief in Satan. And so when they make outlandish claims to want to hold masses or put up statues, etc., I think those would be easily dispensed with under a well-formulated religious discrimination bill.
Thank you, John.
Peter,
Can
I just add something? I hope that, John, I hope you're right. And I'm sure that your close reading is accurate. However, I do think we have to be prepared for the fact that that Satanists will argue vigorously that Satanism is a religion and that they ought to be afforded the same sorts of rights. And that's troubling, but I think the consoling point in all that is that if there is genuine opportunity for freedom of speech and freedom of religious discussion and religious dialogue, then it will be easier to counter the claims made by the so-called churches of Satan. I think however one may judge their, as it were, doctrinal content, they will make the claim that they are a religion. And before, in that campaign, before the recent census, the Say No campaign, the Satanists weighed in on that and were keen to promote themselves and present themselves as a genuine, as a bona fide religious group. So I think we have to be prepared to deal with them. But I think with the removal of constraints, as it were, or the kind of shield that anti-discrimination law can provide, it should be possible. I hope it would be possible to counter that. But it's a worrying development.
Yeah. Thank you, Peter. David.
A question for John, please. That is there any merit in having a Bill of Rights which would enshrine positively the freedom of faith?
So, David, there's many different views on whether a Bill of Rights would be a useful instrument for Australians. I'd point out that the places that have had the most draconian lockdowns during COVID times are also the state jurisdictions which have extensive bills of rights and supposed watchdog organisations which are supposed to ensure that any laws that are passed that would limit those rights do so in the least invasive way possible. And I don't think we've seen that actually happen in that case. So I'm not personally a fan of a Bill of Rights. I know that Professor Patrick Parkinson has often written and explained why Christians are often hesitant to pass bills of rights. Oftentimes they have motherhood statements that everyone can broadly agree on, but which are easily contorted around whatever the ideology, the persuasive ideology is of the day, to give consequences that you wouldn't necessarily associate. So yeah, they have a small central core of meaning and a large penumbra of doubt that can be pushed this way or that to just enforce whatever the popular ideology is of the day. So I'm not a big fan of bills of rights, but I'm sure there are others here who are.
Well, I'll be happy to hear from others there, perhaps Rohan or Peter.
Yeah, I'll just say very quickly that I do agree with John's sentiment about being cautious about a Bill of Rights. As he said, one of the ways it can sort of work itself out is you see judges that are unelected, and this is particularly true of the Supreme Court in the United States, becoming those that read the Constitution in a certain way, usually, unfortunately, in accordance with the majority of and their political prejudices, to find things in the amendments that were perhaps, in the majority opinion, something that truly could not be found. Because there's different philosophical views of how to understand the Constitution there. Is it a living document that changes with culture, or should we read it as the founding fathers intended? And so, and that unfortunately is also then subject to the changes in the political landscape. What president can seat which judges, and then change the composition. So I think that it's preferable to have a system in which our legislators are the ones who are making the decisions as representatives, rather than a smaller group of politicized judges.
Thank you, Rowan.
Can I just add a word to say that I agree with both John and Rowan on this? I'm not in favor of a Bill of Rights for the reasons that each of them has stated. I think we don't want to see these matters being decided by panels of unelected and unaccountable judges. I think that would be a retrograde step for Australia.
Yeah, agreed. Senator, if you look at the Queensland Voluntary Assisted Dying Bill, it was a conscience vote. How do you see the Religious Freedom Bill? Is there going to be likely a conscience vote, or are we going to be political based? What's your feel for that, and anybody else, of course, as well?
Look, I don't know at this stage. Given that this is government legislation, I would envisage that there would likely be a government position. So I'm not sure how that's going to go at this stage.
Okay, thank you.
A question for the Senator again. Is there going to be a backlash one way or the other? Is the government caught between a rock and a hard place here?
Look, this was always going to be finding the appropriate balance here. So I think that whichever way it goes, going back to, I think the point that John made before, each side will find something to hang their hat on, depending on what happens. I think the issue, though, here is that given the divergence of views, it is likely that people won't be happy on either side. And then it comes back to the point about what the religious leaders wrote to then Attorney General and the Prime Minister, that is this such a flawed bill that it's better to have no bill than a flawed bill. And I go back to the point that I made, and that is that in the end, unless all the rights sit equally together, then one will not be subservient to the other, and which is why I have pushed for a consolidation of discrimination law. That is a major issue, but it is also a long-term solution. And once you do equate rights on the same level, then I think it's going to be very different to say, well, one right is better than the other and one right deserves greater prominence than the other. Now, I appreciate that that is a major issue, but I think if we're going to deal with this situation, which is currently just a whole series of silos, if we are going to ensure that there is equality of rights in the terms that the government has said, then I really do think that a consolidation of discrimination law ultimately is going to have to be the way that we do go to properly give effect to equality of rights.
David, one more if we could, please. I think we're going to run out of time. David, can you squeeze one more in for me? Thank you.
Yes, well, this one is really about general issues. Peter, you've written about coon cheese. What's behind this name change problem? Have we got this off our chest culturally now, or is this just going to go from bad to worse? And have the makers of coon cheese seen any loss of sales?
I don't know about the loss of sales. So I don't know what the commercial implications of that name change have been. The name of the changed name of Coon cheese was odd because the product was named after the manufacturer or the person, the inventor of the process. And I thought that in that instance, it ought not to be changed. But there was an island at Lake Macquarie, the name which I've just forgotten, that was named after a miner. Let's say it was Blackie's Island, I can't remember, but that was not the man's name, it was something else. He was nicknamed that because of the coal dust. And finally, there was a move to change the name, and the family of this long deceased miner agreed with that change. And there are things, I think, where society needs to move along, and we need to review the way in which we name things, and we can revise our stand on various issues. But I think it's done best on a case-by-case basis. Just because the association of Mr. Edward Coon with a racial epithet had lodged here doesn't mean to say it was appropriate. And what about other people whose names may be not spelt C-O-O-N but are pronounced Coon? What about those people? Are we going to vilify them as well? So I think that we have to just take these things on a case-by-case basis, as I say, but I don't think it's necessarily a bad thing to take stock of the words that we use on a daily basis.
Thank you.
Well, they certainly lost this customer.
Thank you, David. Well, it's called cheer now, so you can all cheer up. Look, can I, on behalf of Family Voice Australia, and in particular our governing board and our members who support family, faith and freedom, Connie, Peter, Rowan and John, look, thank you very much for helping us make sense out of what's going to be a big issue as we come to October, November and into the election year. This is not by any means an easy topic to deal with, but can I just say also that each and every one of you have provided a wonderful insight into what's going to be an issue for us. So can I thank you sincerely? And I'd like to hand over to David. You can see how I palm these things off. Well, David, to end in prayer, because I want him to pray for me rather than me for him. So David, please end in prayer, and then I want to thank you once again for coming. Thank you, David.
Yes, let's pray again. Our Father, we thank you for the opportunity we've had tonight, for the excellent input. And we ask that your blessing will be upon all of our participants, especially be with Senator Connie as she's leading the charge there in the federal parliament on so many of these issues, anti-discrimination concerns. And we pray for John Steenhoff in his work at the Human Rights Law Alliance, and be with Rowan McHugh as he's the Executive Director leading the Freedom for Faith organisation, and be with Peter Kurti at the Centre for Independent Studies. We pray for Greg as well, and for
great.
all of our Family Voice team, and help Family Voice and other voices for freedom of faith and freedom of association and freedom of contract and all of these wonderful freedoms that you've given to us because of our freedom in Christ. Be with Family Voice and these other groups, we pray, as we tackle these challenging times in Jesus' name. Amen.
Thank you, David. Thank you once again, John, Rowan, Peter and Connie. You are wonderful. This will be recorded. It's a webinar. I'll make sure you get a copy. And in the meantime, our prayers do go out for the work that you do in the name of our Lord. Right. Thank you and good night to everybody.
Good night.
Good night.
Good night, everyone.